Okay, today's subject is the law and your legacy. I'm attorney Pete Hamilton,
And I'm attorney Ryan Hamilton.
and we're here today to discuss property disputes among heirs. And I'm going to first start have Ryan to sort of give a definition of what an heir is.
An heir, I guess textbook definition, an heir is your blood relative, right? And most of the time, this is going to be your children. However, if you only had one child and that child has predeceased you or died before you, then your grandchild would be your heir. And then it's basically a line of succession. If you don't have any children, but you have brothers and sisters, then your brothers and sisters would be your heirs. If you don't have any children or brothers and sisters, then your parents would be your heirs, or possibly if you're married, your wife could be your heir. But there's a set structure on who is your heir when you pass away, and the first priority are your children.
Correct.
If you have them, and then it kind of goes around. But that's what an heir is.
Well, this is the problem, and this is why we're discussing the subject today. If you decide not to do a will, because we're back on the subject of doing wills, the civil code decides who your heir is.
That's right.
So what has happened historically when individuals don't have a will or, with our earlier discussion, a trust to say how they want their property distributed, then the conflict becomes between the children, each of the children, maybe the children's or the grandchildren, and who should have received certain things. The subject I always think about is the individual that stays home with their parent. They have 5 siblings. They stay home with their parent, and the parent tells them in the living room, when I die, you can have this house. And they think that the house belongs to them. But that needs to be in writing,
Right.
and it needs to be distributed based upon that intent. If the parent wanted that one child to have that house, the parent would either have to put that in the will or to put it actually in the trust. Because under the law, we make it real simple, under the law, if there were 5 children and you passed away, your 5 children would inherit equally that property. So what we need to do is we need to talk about how, and well, we said it earlier.
I could address that point right there. 2 misconceptions that we hear all the time that people come into office. They think I'm the firstborn child, so I get everything.
Well, we've heard that.
We hear that all the time, and that's not correct. And then another one we hear all the time is husband and wife had 2 children. One of their children passed away before them, but that child who passed away first had a child.
Right.
That living child thinks everything belongs to them, and they don't need to give their niece or nephew anything.
Correct.
And we see that all the time. That that's my mama's house. Why would they? And they never came around. They don't know me. They don't live here. That doesn't change anything. That's still
right.
That's still your brother or sister's child, and they're entitled to their parents' share through representation. Right. To use a $10 word, as they say.
I think another issue that comes up is the issue regarding the surviving spouse.
That's right.
So what you have is that there are many cases where in many places the surviving spouse will inherit the community property,
right.
But not in Louisiana.
That's right.
So I'll just use a simple example. A husband and wife have a home together, and then I'll let the husband pass away, and they had 2 children, then those 2 children would then inherit half of the house that's owned.
That's right.
The wife would not inherit the house.
She would have a usufruct.
She'll have it. That's a whole nother subject. We're
but-
talking about the use and the fruits of the property, so she could continue to occupy it.
Right, but she doesn't own. She owns her half. She doesn't own the spouse, her deceased spouse half.
That is correct.
What I see are the most people doing planning are younger black women from the ages of 35 to 55.
Okay.
And they're doing they're in two capacities. They're coming in as for themselves to handle their affairs. Most of the time, these are single black women who are handling their affairs, either whether they have children or not, and then, or they're coming in bringing in their father who's remarried.
Well,
To make sure, is that his separate property, is that community property, who's he leaving his things to?
Right.
So they kind of dragging him by the horns to come in and maybe do a trust or do a will to say that this house that I grew up in, that we don't want this to go to your new wife. We want to make sure that this goes to us and.
Right.
And
well, we see that a lot. I think the new blended family with children from the first marriage, and then children from the marriage together, they are perfect examples of people who need to identify how they want the distribution. I've had clients who actually have come in the office and have made a decision that they don't want to do anything.
Right.
Yeah, they just let the law decide
Right.
how the distribution is going to be made.
Right.
Which really complicates everything between the parties, because if there's no real directive on what you want, then you have this combat between, as you're bringing up, the older children versus the younger families, or the younger children from the earlier families. We can say quickly, though, we want to talk about there is still forced heirship in Louisiana, so that needs to be addressed. And forced heirship, define forced heirship for me.
Forced heirship is a child, one of your children who has not turned 24, or a child of any age who has a mental or physical disability that does not allow them to care for themselves. So they have some type of special need.
So that basically means when there's a forced heir and you wanted to make a will, you cannot exclude those
forced heirs.
Those forced heirs. They have to be considered within the calculation.
Just running back to the top, when I defined heirship, I didn't talk about separate property versus community property, but there's a different line on how separate property would be distributed versus community property.
Which is a subject we probably ought to address in our next presentation, that we get a chance to address separate versus community.
We'll talk about that in detail, what that is.
Okay, that's a good idea.
Just a reminder, this is not legal advice. It's just a tip brought to you by Liberty Bank and Trust. For more information, go to libertybank.net or contact me at 504-915-5016.